right, good morning, everyone. Let's try that again. Good morning.
Good morning.
Woo! Everyone is excited to be here about Foia, right? Good morning. Welcome to Sunshine Week Foia training in Fairfax County. I'm Amanda Castle, the countywide Foia officer for Fairfax County. As many of you know, this week is Sunshine Week. Sunshine Week is a nationally recognized celebration of open government. So today we are celebrating Sunshine Week and the work of each of you here and the contributions you have made as local government Foia professionals. So a quick thank yous to some folks who made this event happen. Obviously, I want to give a big thank you to all of you for joining us here today to support open government in local government in Virginia and to learn more about the Virginia Freedom of Information Act. I'd also like to thank our guest speaker, Alan Gernhardt of the Virginia Freedom of Information Advisory Council, who, by the way, traveled over 100 miles to get here. So thank you, Alan, for coming. Also, thank you to Beth here in the County Attorney's Office, who we will be hearing from shortly. And then a big thank you to the Fairfax Office of Public Affairs FOIA team, Molly Shannon, if you can raise your hand, and Jessica Gonzalez, who I think is probably continuing to work outside. From printing programs and name tags to coordinating registration, this event could not have happened without them, so I really thank the FOIA team for that. And also we had some folks in the County Attorney's Office assisting us with registration, Lou Nuzzo and Sarah Anir and Eloisa. We appreciate everyone helping us with that as well. And obviously the Channel 16 production crew, this is being recorded. You'll see some cameras. Thank you to you all, the producer Valerie Bay, for making this happen and recording this as well. So we're going to start off with a little icebreaker to warm us up. Hopefully the pastries and coffee already did that a little bit. But we'd like to understand a little bit more about who's here with us today. We've got quite the crowd. So by a brief show of hands, who here is your jurisdiction's FOIA officer or on the FOIA staff? Wow, that's a lot. Awesome. How about attorneys, paralegals, legal staff? Yeah, that's a lot too. How about PIOs or communication staff? Okay, IT professionals, access professionals, programmers. Okay, a couple there. And last but not least, our public safety folks, fire department, police department, 911. Yeah, I knew those hands would go up. We all love FOIA. All right. Well, we certainly have a diverse group of attendees here with us today from a variety of backgrounds, as you could see. We actually have over 23 Virginia jurisdictions here with us today. It's very, very impressive. And many of you have traveled long distances to get here. So by a show of hands, who, in order to get here, traveled 20 or more miles? 50 or more miles? Wow. Raise those hands higher. You deserve it. 75 or more. 100 or more. 200 or more. Oh, 175 or more. Is there someone from Wise County here? Stanton? How many miles did you all travel over here? Let's get you. Let's try to figure that out. Okay. All right. Well, I think the Stanton is going to be the farthest folks that have traveled here. We are excited to partner with the FOIA Council to provide a forum to learn more about FOIA. We like to call this group what I like to colloquially refer to as our FOIA fan club. So it's only appropriate that given you've traveled so far, you are clearly the biggest fan. All right. And for all the others that traveled over 100, obviously, you're up there too. The couple program logistics items before we get started, please do kindly silence your cell phones. This is being recorded. The event is being recorded, and we have mics and what we call a catch box. If everyone can see this blue box in front, it's kind of cool. It is not breakable. If somebody has a question, if you could please raise your hand, and we will throw you the catch box so that you can ask your question. In order to hear you, we need to make sure you have a mic. So please do also state your name and your locality before you ask a question. All right, so moving right along, I was very fortunate enough to work in the Fairfax County County Attorney's Office for nearly 3 years. I actually see the person who hired me right over here. And I owe much of what I know about FOIA to the County Attorney's Office and the experts who continue to help us, Lou Nuzzo and Sarah Anir, who are sitting right here. And we continue to rely on this office for legal advice. I'm excited to be able to introduce the leader in that office, County Attorney Beth Tier, who will introduce our guest speaker.
Thank you, Amanda, and good morning, everyone. I am Beth Tier, County Attorney, and I want to join with Amanda in sort of congratulating ourselves on such a strong working relationship that we have with OPA and the FOIA team in that office. Within our office, we do have 2 attorneys who work full-time on FOIA requests, thereby demonstrating our absolute and unfailing commitment to ensuring transparency of government in accordance with FOIA. And specifically, we have with us Lou Nuzzo and Sarah Anir, who are very ably led by Cynthia Bailey in my office. Other attorneys throughout my office work on a constant basis as well to ensure that everyone is completely compliant with their FOIA obligations, again, in a very firm and strong effort to ensure that government remains transparent and open for all. I am very pleased to be asked to introduce our guest speaker. This individual is very well known to our FOIA team and OPA, as well as the attorneys in my office who devote their time and talents to ensuring FOIA compliance. And our keynote speaker, Alan Gernhardt, is the executive director of the Virginia Freedom of Information Advisory Council. He began working with the council as a staff attorney in 2004, was promoted to senior attorney in 2008, and became executive director of the council in 2017. He earned his Bachelor of Science degree from Indiana University and his law degree from the University of Richmond T.C. Williams School of Law. For those of you who may not be familiar with the council, I urge you to become familiar with them because they are, again, an invaluable resource. The council issues formal and informal advisory opinions, publishes educational materials, provides training presentations, and serves as a legislative forum regarding access to public records and meetings under the Virginia Freedom of Information Act. Again, we are delighted that Mr. Gernhardt is able to join us today to speak about FOIA, and again, thank him for his rather harrowing travel up 95 to join us. Please join me in warmly welcoming Alan Gernhardt.
Thank you. Good morning. Really? Let's try it. You'd have to do it twice too, right? Let's try that again. Good morning.
Good morning.
All right. I like that. So I'm Alan Gernhardt. I have been with the FOIA Council since 2004, as you heard. And let me ask, how many of you have called me before? Okay. How many of you have spoken with Maria, who used to be executive director? Okay. So a lot of you already know what we do. How many of you don't know what we do? Okay, let me give you a little roadmap. For today's course, we are doing this for legal education credits, and for that reason, we're going to follow the hour-and-a-half timeline. We're going to start kind of with some general overview of what the council does and why we have FOIA. It is Sunshine Week. It's time to celebrate FOIA. I'm going to see if I can make you all love FOIA. It's a challenge, I know. But then we're going to go into the basic program, which is what are public records, how to recognize a FOIA request, how to make a FOIA request, how to respond to a FOIA request. We'll talk about charges. We'll talk about differences between paper records, electronic records. We'll get into some of the general exemptions. Since we're going to go an hour and a half and we're scheduled for a full 2 hours, I will stay after we end the CLE part of the program for those who have specific questions. And I know a lot of people are shy and they don't want to speak up during a program, so you can always ask it after, or you can call us or send us an email. So to start with, what do we do as the FOIA Council? We answer your questions. That's what we're here for. We provide guidance and advice on FOIA and access to government records, government meetings. Last year, I think we had a total of about almost 1,900 inquiries that we handled with a staff of 2. So, I mean, this is what we do pretty much full time. We issue advisory opinions that are informal and formal. The informal means phone or email, generally, or in person. Formal advisory opinions are published on the website. Over the years, we've noticed, we have fewer requests for the formal opinions. A lot of that is because we have built up kind of a body of law already. So most of the simple questions, you can find an opinion on it already, and we don't need to do a new one. A lot of the newer opinions tend to be more esoteric and nuanced questions for that reason. Other stuff we do, if you ever need a response letter, we've drafted sample response letters. They're all up on the website. Electronic meetings rules, some of the sample forms, public comment forms, all of those things can be found on the FOIA Council website. Did you have that to put up the website? Did you want to just show that? Yeah, just so everybody can see it. It's got this yellow background, which is for Sunshine Week. If you look down towards the bottom, you'll see the contact information. That's probably the most valuable thing you can take with you today because, like I said, you can always call us or send us an email. When you look at the different categories on the website, you'll see about the council is exactly that. It's information about the council itself. When you look at the FOIA officer's information, I'll tell you, for anyone who is a FOIA officer, if you use the online form, that will automatically add your information into the FOIA officer's list. If for some reason the online form isn't working for you, we also have the Microsoft Word version, so you can turn in your information that way. In between those things, there you'll see the free FOIA training. That's for people. If you don't do the live training like we're doing today, you can always do it through the Commonwealth of Virginia Learning Center, and that outlines the steps of how to do that. Also, how many FOIA officers did we have today? Okay, for those of you who would like certificates for attending today's training, please contact me. You can just shoot me an email at the FOIA Council address. Tell us your name, your locality, and that you attended today's training, and we can provide you a certificate because this does count for your annual training. Okay. Also, for CLE purposes, you got the CLE form. If anybody needs one, you can also contact me. Okay. Let's get into it. I like to call on people. I like volunteers better. What's FOIA mean to y'all? What kind of words come to mind when you think FOIA? In the back. Headache. I'll tell you, it's a running rivalry right now. When I ask that question, the top answers are usually headache or pain in the... Let me ask you, do you love FOIA? Would anyone like to say yes? I got a yes. I'm a yes. Anybody else a yes? Do you think I can make you love FOIA? I see heads shaking, I see head nodding. Everybody understands the difference between love and like? All right. Do you like FOIA? Maybe, maybe not. I'm not going to try to convince you necessarily to like FOIA, but I'm going to try to convince you to love FOIA. It's not going to take long. I want you to think about our government. What kind of government do we have? I heard a long answer, louder. Representative democracy. Yeah, I've heard a representative constitutional democratic republic. Anybody like that? Yeah, that's it. What does FOIA have to do with that? Did we always have FOIA? No, we've had FOIA in Virginia since '68. Federal FOIA, I think it was originally passed, I think in '64 and signed and went into effect in '66. So we're going about a little over 50 years of FOIA. But what does FOIA have to do with government? How about the Declaration of Independence? Anybody remember who wrote it? Declaration? There you go, Jefferson. Yeah, Thomas Jefferson. One of the things he wrote in there, he talked about government by consent of the governed. So I'd like to ask everybody, who here is a citizen of Virginia? Anybody not? Yeah, I think we have a couple not. Are y'all DC, Maryland, or shout it out. Where are you from? DC? Okay. Most of us are citizens, and y'all are citizens of the country, even if you're not citizens of Virginia. This is going to become important in a minute. But government by consent of the governed. Have y'all gone to the doctor before? Doctor wants to do something, and he's got to get your... What kind of consent? Informed consent, that's right, because if you don't really know what he's going to do, it really doesn't count, does it? If he was to say to you, you're actually really sick. I know you don't feel sick, but you're really sick, and I'm going to need to knock you out and do some procedures, and I'll stitch you up good. You'll be fine afterwards, okay? Anybody going to agree to that? Same concept with government. If we're going to do government by consent of the governed, it's got to be informed consent for it to be meaningful, right? That's where FOIA comes in. This is how people get to find out what our government's doing. Okay, so now I said I was going to make you love FOIA. That might not have been enough. So now I want you to imagine a government that doesn't have FOIA. Think of any? Throw one out there. I heard one. Russia, someone said. Russia actually has their own version. They do. I'll tell you, there are a couple of the exemptions. Did an exchange program with some people from VCU, including some Russian groups. And one of them, we were talking about some of the exemptions we have here in Virginia, and they're like, wow, that would be criminal in Russia. You can't withhold that. Yeah, so even Russia has some. I did this program for VML last year, and a woman in the crowd had a great example. She said, I grew up under Ceausescu. They don't have FOIA, not then, not under a dictator, especially not a dictator committing genocide, right? Anybody want to live under a dictator committing genocide? No. Do you love FOIA? All right. Now that we have the right mindset, let's talk about some of the nuts and bolts of FOIA. Okay. First off, what's a public record? What do y'all think is a public record? What comes to mind? Shout it out. Don't be shy. Public contracts. There's one. Police reports. Yeah, can be. Email? All my emails. All your emails. Well, let's talk about the definition of a public record, and we'll talk about email, too. It's a good example. So, definition of public record. Code section 2.2-3701 says public records means all writings and recordings consisting of words, letters, numbers, their equivalent set down by, and then has a nice long laundry list of ways you can create a record. However stored, regardless of physical form or characteristics, prepared by, owned by, or in the possession of a public body, its officers, agents, or employees in the transaction of public business. Would you like that again? Let me break that down. Yes, and if you'd been doing this 15 years full time, you would be able to just spew that out there. Okay. I like to break it into three parts. First part is we're talking about all writings, recordings, etc., however stored, regardless of physical form or characteristics. Well, it's got to be a record, right? We are recording this, so there will be a record of this training. Most of my trainings aren't recorded. So if you had gone and said, hey, you know, I heard you were in Leesburg last week. I'd like to compare the difference between your Leesburg training and your training here in Fairfax. Can I get a copy of the Leesburg one? I'd have to tell you, sorry, no, it wasn't recorded. I don't have a copy of it. But this one is recorded. So first, we've got to have a record. Second, prepared, owned, or possessed by the public body, its officers, agents, employees. Well, first one, pretty obvious, prepared. You know, we're government and we made it. We prepared it, okay, we meet that one. Owned, again, usually pretty obvious, not always though. Sometimes we own something that we don't possess or we didn't prepare, like when you hire somebody else to do it for you, okay, but you may have a legal ownership interest, constructive ownership, that kind of thing. That doesn't come up too often, but occasionally it does. And then the last one, possessed. This is one where you didn't prepare it necessarily. You don't own it necessarily. This is a constituent writing to their county board member or town council member about some matter of public business, which is the third requirement. Has to be the transaction of public business. There was a case a little over 12 years ago in Loudoun County where someone asked for supervisors' emails with certain other individuals. they said, well, here are some of them that are about public business, but we're going to deny the rest because, we are friends with these people, we have personal stuff, and we're not going to give you the personal ones because those aren't subject to FOIA. At the general district court level, the court said, hey, wait a second, y'all are elected officials, you got to turn everything over. They appealed it up to the circuit court, though, and the circuit court said, no, that's not right. You ignored the part of the definition that says transaction of public business. You only have to provide it if it's transaction of public business. So, emails were mentioned. Well, are all your emails public business? Anybody ever get an email with a cute little picture of a cat? Little caption on it? Yeah, okay. The internet's all about cats, right? So, email about cats. I think almost everyone has seen something like that. Is that FOIable? Well, is it? Speak up. Right, not the transaction of public business. Unless it's got a caption saying, hey, we need to vote on that ordinance next week. Don't forget to put it on the agenda or something where it actually is public business. I mean, most of those things, they're personal. Social events, note from your spouse or significant other, hey, pick up milk on the way home, or the kid's going to be late. Don't forget about the after-school program. I mean, all that kind of stuff. It's not really subject to FOIA. At this point, I want to turn to question here. We had one of the written questions that was submitted is, can you provide a definition for the transaction of public business? No. The statute does not set out a definition of the transaction of public business. I can tell you there's a number of our opinions, Attorney General's opinions, and court opinions that have looked at it, and it does include procedural things. This is where people get caught up sometimes, especially on the meeting side of things. Things like emails scheduling a meeting, those are public business. A retreat for a board or governing body, that's public business, even though what they're really doing is learning how to conduct public business. That in itself is the transaction of public business. So there's no statutory definition. I usually try to go to a very practical standard and say, if you're government and you did it for work, yeah, it's probably transaction of public business. Okay, and this is something that there can be fine line things, because sometimes someone has a personal matter that somewhat overlaps with their job duties. And so it can be a nuanced question at times, but generally, if you did it for work, I would treat it as public business. Okay, part of that, there is, in the very beginning of FOIA, a policy statement that says everything in FOIA is to be liberally construed in favor of openness, except the exemptions, which are to be narrowly construed. So I usually call this kind of the Johnny Cochran moment. When in doubt, give it out. Okay? It's a simple way to, they've given you a conflict resolution kind of idea right there of, hey, if you're not sure, construe in favor of openness. So that is the policy of FOIA. Okay. Any questions about the definition of a public record? Let me ask that. Any others? Okay, I don't see any hands up. Let me go, I said I would talk about email a little bit. So a couple things to keep in mind with email and social media, okay? FOIA doesn't care about the type of record. So can a Facebook post be a FOIA-able public record? As some of you may be familiar, this is an issue that's going before the federal courts right now. It's already been to district court, and there are appeals going on. So we're kind of waiting to see what the courts say to get a clear answer. But it does appear that, yes, a Facebook post, any other social media post can be a public record if it's in the transaction of public business. Some of these things would be obvious. You know, if the county has a website and you post a meeting notice up there for people to see, clearly that would be a public record. Other things less so, with elected officials and employees talking about their jobs and their positions as officials. This can be, maybe not. There are some nuanced questions. The courts are looking at it, so we're just waiting for the courts to give us an answer on that one. What about personal email accounts? Can those be public records? Have them? Yeah, sure. FOIA doesn't care what account you use. FOIA doesn't care what device you use. So as best practices, people advise, if you have a government account, use it for your government business. If you have a government computer or other, county-issued cell phone, that kind of thing, try to keep your public business on that device, that account, just because it's best practice. If you do public business on a personal account or personal device, that's still subject to FOIA. And if there are problems later and you go into litigation, it could be subject to discovery. And I know I was at a ethics CLE yesterday where they spoke about it, and they said, well, you know, if the federal court decides they want to see your emails, they're not going to just say turn over the email, they're going to say turn over the whole device, the entire hard drive. I want to see everything that's on there. And then they'll decide what becomes public. Okay, so keep that in mind as a best practice. On that note, there was another question here. In terms of FOIA retention requirements, does a FOIA response include both the response and responsive records that are provided to a requester? FOIA doesn't have retention requirements. I get to pass the buck a little bit there. It's the Virginia Public Records Act where you find all the retention requirements. If you need to look at specific ones, the Library of Virginia administers that act and sets all the retention schedules, so you can go onto their website and find their retention schedules. I know for FOIA requests, whatever materials you've kept for that, you're supposed to keep for 3 years. I don't think they usually make you keep the actual records you turn over under that 3-year retention, because they're going to have their own retention period depending on the type of record. So, for example, if someone were to come to me and make a FOIA request for some of the council's meeting minutes, our meeting minutes are permanent retention. So I would keep a record of their request for 3 years, but my meeting minutes I would keep forever. Okay, so they could have 2 different retention periods. Any questions on that? Okay. Let's go into the other part of the FOIA policy that I was speaking about. All records are presumed open. All of the public records are presumed to be open to the public by default unless there is a specific exemption or prohibition that either allows them to be withheld or requires it. This is an important conceptual distinction. Within FOIA, there are a couple prohibitions now, but the vast majority of about 150 exemptions are exemptions from mandatory disclosure, but they are not prohibitions. They do not require you to keep stuff confidential. They allow you to keep it confidential. The difference being, if, for example, you came to my boss and said, Alan did this CLE, but I mean, it was terrible. I don't believe he's even an attorney. Can you show me his resume and show me that he actually went to law school? They could say, yeah, he's an attorney, here you go. And they could give it to you. Now, that stuff's exempt. It's a personnel record. They don't have to give it to you, but they can choose to do so. When you go through FOIA, you'll see prefatory language on almost every exemption that says, the following records are exempt from mandatory disclosure, but may be disclosed in the discretion of the custodian. So that's where that idea of you can turn them over, but you don't have to comes in. There are a couple things that are prohibited. Right now in FOIA, the clear prohibitions concern the identity of people providing information about a crime under a promise of anonymity, and certain student records of phone number, email address, and address of students. Those ones are clear prohibitions. Other than that, pretty much everything in FOIA is a discretionary exemption, okay? Just to have that concept. The other thing, keep in mind, FOIA is kind of the default mechanism for getting public records, but it is not the only mechanism. We've already mentioned you might end up in court sometime and have discovery. The discovery rules are totally different from FOIA. The FOIA exemptions do not apply if you're in court. So keep in mind there's a distinction there. Okay. Any questions about that part? No. Good. All right. Let's talk about making a request for public records. Oh, go ahead.
We did have one. We did have one question submitted. We did have one question submitted relating to exemptions that perhaps we could ask, if that's okay. Is a county employee's email address considered exempt under Virginia FOIA? And what about contact information of members of the public who contact the public body? And this would include animal adopters, permit seekers, FOIA requesters, library card holders, meeting attendees, 911 callers, complainants, volunteers. We could probably name several others, but we would love if you could address that.
Sure. That's a little more complicated than it sounds. So first, a visual. This is FOIA, single-spaced, printed out, 58 pages. So clearly, and like I said, there's about 150 exemptions. We're not going to get to everything, but that's two of the big ones. You will see the personnel exemption allows you to withhold personnel information about specific individuals that are identifiable. So for the county employee email address, if it is your home address, your home email, your personal email, yes, it may be withheld as personnel information. If it's the one issued by the county for the purpose of people contacting you, then no, you can't withhold that. Okay, the whole point of that is for public contact. I would say the one exception there is undercover officers, because they have a special exemption where you don't reveal their identity. So anything that would reveal an undercover officer's identity, you can withhold. Okay. Now, as far as constituent contact, basically citizens, library card holders, etc., we would have to go through all the exemptions to identify all the possible situations. Generally speaking, there is no general exemption for personal contact information. There is an exemption for personal contact information when you sign up to receive email from the public body. This was specifically designed kind of as an anti-spam measure. For the lawyers, you'll find it at subdivision 10 of 2.2-3705.1. It was rewritten a couple years ago to clarify, because it used to just say personal information and then it had other details, and it referred out to a different act, and there was some confusion about its application because of that. So now it says contact information, and it's a little bit clearer. There's a specific exemption for library card holders if it identifies both the person and what they checked out, but not if it's either or. It's a specific one. There's a number of other tweaks and stuff. I mean, the big ones that deal with personal information, though: personnel records for people who work for government, scholastic records for students, both K through 12 and higher ed, and then also health records. Those are three of the big ones. There are others, though. So if you have a specific question, I would say go ahead and contact us, and we'll be happy to talk about it. All right. Making a request and who can make a request. We did have also a couple questions that I put in the who category. So first thing, let me ask, everybody here government? Is everybody a government employee or official? Is anybody not government? Okay, everybody here is government. Sometimes we'll have a member of the media or someone who's just a curious citizen in the audience. But we said earlier, citizens. How many of you are citizens again? Yeah, and a couple are not, right? Okay, so who can make a Virginia FOIA request? That was a big hint. Citizens of Virginia. Anybody else? Yeah, members of media. Specifically, it's representatives of newspapers, magazines, radio, and television that have broadcast or circulation in or into the Commonwealth. Okay, so media in Virginia and citizens in Virginia. So for the people who are not Virginia citizens, do they not get to make FOIA requests here? Can they ask? Sure. Would you answer? Okay. That's a mixed thing. For the attorneys, again, this has gone up to the Supreme Court. The citizenship issue was challenged. The case was McBurney versus Young. And the court upheld our limitation that we can limit it to our own citizens. And a lot of that traced back to they're the ones who pay for these records to be created in the first place through their tax dollars. Issues have come up. I know there was at least one locality that had an employee who lived in Pennsylvania, and she asked for certain records and was told, no, you're out of state. We don't have to give them to you. DC? Could you say no to someone who's a government worker but lives in DC? More importantly, would you? I would advise you not to, okay? Because for someone living in DC working in Virginia, don't you think she knows a Virginia person? And she can just turn to her coworker, hey, they won't give it to me. Will you ask for me? That's all she has to do. And then you're on the hook to respond anyway. Generally, in our experience, anybody interested enough to be asking you for records is probably interested enough to follow up and get someone else to do it for them. So usually if you just say no, I mean, you can do it legally if they're out of state requester, but they're usually going to come back with someone else. So we advise to go ahead and respond and deal with them and just work out a deal and do it that way. I would also point out, I have heard now of two organizations, muckrock.com and FOIAprofessionals.com, both of which will be happy to provide someone to make a Virginia FOIA request. So, I mean, literally anyone can just get online and find someone to make a request for them. So, for that reason, we advise go ahead and respond to everybody. Any questions about that? All right. How do you make a FOIA request? What do you have to do? Yeah, ask. What do you ask for? Public records, I heard. And what was up here? Reasonable specificity. There we go. And actually, topic was mentioned. Topic is a good way to ask for records, but it's not the only way. You could ask for, I want every report done by this particular employee or in this department for this time period. And they may be on different topics, but it would still be a valid FOIA request because you know how to find it. We've given that a very practical interpretation. It says the requester must identify the requested records with reasonable specificity. We said if you can tell what they want, that's reasonable specificity. You may need to follow up with a couple clarifying questions, but as long as you're there, you know generally what they want, that's okay. Now, one of our questions in here, oh yeah, this is also on the WHO. Are media companies who are online only considered members of the media with circulation in Virginia for purposes of FOIA? What do y'all think? Online only? Is that media? I'll tell you the truth, I don't want to talk about it. I don't even want to think about it. I don't have an answer for you. They're not specifically included in FOIA. Again, we advise responding to everybody, so I would respond to them. Because, if you say, oh, you're CNN online, I don't have to give you that. I also work for CNN. We're on TV. We're in Virginia. They're going to do something like that. Or they're going to go to Muck Rock or FOIA Professionals or someone else. They're going to come back at you. So I will tell you, the only place I've seen any real discussion of whether or not online media is usually for media shield laws, where they're trying to protect their sources. So that would be one area of law to look at, but there are no FOIA precedents that I know of for that. Double checking through here. Oh yeah, this one. I like this question. Do you recommend negotiating with a requester to narrow or clarify the scope of a request? Should we consider a revised request a new request for FOIA response deadlines? Okay, so this goes back to reasonable specificity, that idea. First off, yes, you should definitely talk to a requester. Always communicate with your requesters. If you can communicate with them, you can solve 90% of your FOIA problems right then and there, because you can always make a deal with them. If you need an extra day to respond and you talk to the requester and say, hey, can I just have one more day? I need this because. Most people are reasonable and they'll be like, yeah, sure. If you need an extra week, they might say, well, if we're talking weeks, we're probably talking a big request, right? We're talking charges. They're probably going to say, tell you what, will you give me a discount? Well, yeah, let's work out a deal. I'll give you more time, charge you less money. You can work that out. Other times it's, wait, that request is going to cost how much? Hold on, maybe I don't want all that stuff. Let's narrow it down. That's always okay. It's a good thing. It helps everybody save time and money in the long run. So I definitely encourage that. The second part of that question, should we consider a revised request a new request for FOIA response deadlines? That's a little more iffy. Everybody remember Venn diagrams from math class? When you get the circles and everything? I kind of look at this as, take this circle, and if this is your original request, I want every report the county did for the last 10 years. That's going to cost me hundreds of thousands of dollars? How about if I just get the reports on one topic for a 1-year period and they just narrow it, but it's within that same circle? I'd probably count it as still in the same ballpark. That example's not the best because there's a question, if you ask for that much stuff, is it really reasonably specific? Well, I'll tell you, volume is not a reason to deny a request. They can ask for as much stuff as they want, but depending on how they phrase it, it may not be a reasonably specific request. If I was to come into the county attorney's office and say, I'd like to see all your papers. Is that reasonably specific? No, probably not. On the other hand, I want to see all your papers regarding this particular case from 8 years ago. And maybe it was a big case. Maybe there's a lot of stuff. Well, that's okay. Or maybe there's not. Maybe it's little. The volume is not a yes-no thing. It's really specificity. Questions about making a request, being specific? Okay, how about forms? Do you all use FOIA forms? Some do. Anybody not? Okay, we have some not. You don't have to. Citizen doesn't have to either. Do they have to put their request in writing? No, they do not. They can ask just about any way they want to. I would encourage you, if it's a really routine thing, I wouldn't worry about it because people forget things like, I'll use this example. My child comes home, she wants to go on a field trip. We need to fill out the permission slip. Daddy, I lost it. I think I dropped it on the bus. Okay, well, go and ask for another one tomorrow. So she goes to the office and, can I have a copy of the the permission slip for the field trip? Is that a FOIA request? Yeah. Yeah, it is, isn't it? Do you ever think of it as a FOIA request? Do you worry about it? Or does the school person just go, yeah, here, and you're done? Yeah, I mean, hopefully something routine like that, you just do it. You don't worry about it. Other things build up, but, we talked about FOIA trackers a little bit. You mentioned that. Do you include routine requests like that in a FOIA tracker, or just the bigger ones? All of them. Okay, so the county tracks all of them. I know some other counties do that. Some state agencies have FOIA tracker systems. Some do, some don't. There's no requirement for that. It's up to you. It's your own decision how to do that. But yeah, for making a request, normally something like that is going to be, verbal. I'd like a copy of this. They're going to say here, and you may or may not track it at all. If there's any question, I would go ahead and write it down. If the person who's making the request doesn't want to write it down themselves, write it down for them. If you have a form and they don't want to use the form, but you really want to put it on the form, go ahead and write it down on the form. There's nothing that says you can't. But I will remind you, and this is a phrase we use a lot, the consequence of choice. Okay? If you write something down on a form, what have you created? Yeah, public record. That's not right or wrong, it's not good or bad, it's just the consequence of choice. We were talking about email a little bit earlier. How many people like to email your coworkers? How many of you will send an email rather than walk down the hall or pick up the phone? Okay. Is this good or bad? No. Is it right or wrong? No, unless you have a policy about it. But as a consequence of sending the email to your coworker, if it's about public business, you create a public record. Whereas if you walk down the hall and just have a verbal conversation, there's no record of it. Now again, we're not saying right or wrong, we're not saying do one, do the other. We're just saying it's something to be aware of. And since we've already mentioned record retention, that's something else to keep in mind. If you create a record, you may have to keep it for some period of time. So be aware of that. Okay, questions about making a request. It's basically be a citizen, be media, or be anybody. Ask for what you want in a way that people can tell what you want. You can write it down, you don't have to. You can do it by email, in person, over the phone. I've seen them by fax, just about anything. Go ahead.
If the data only resides in a digital backup format and the record has been properly disposed of, is it still FOIAble?
Okay, if it is a digital record, I think it depends on whether how you have it. It becomes a technical question. For example, if you've hit delete on a standard record and it goes into your little recycle bin, but you can just go to the recycle bin and pull it right back out, I wouldn't count that as deleted. I'd say you still go ahead and do it. If you've done, what some people call a hard delete or whatever, the shift delete, and it's actually gone, and the only way to retrieve it would be to have, forensic IT come in and search the magnetic sectors on your hard drive, that's a different issue. That comes up more in discovery. I don't think at that point you'd go for it under FOIA. With backups, though, depending on what systems you have, those records may exist on an emergency recovery backup, or if you have an email archive system that stores everything, and some people do, it may reside there. So even if you don't have it on your desktop, the public body may still have a copy. So I would discuss that with your IT professionals to see, do we have it or not at that point? Okay. I think we've covered requesting records. Any other questions about making a request? All right, let's talk about responding. Oh, you have one? Okay, up there.
Bring you a mic, 1 second. Okay. All right, look out, y'all. Okay.
Hi. So my question is about determining if somebody is a Virginia resident. Mm-hmm. And because we're a small office, we generally deny out-of-state requests the first time. But I request a legal address.
Yes.
A street address, and I get some back that say Alexandria, Virginia, and I say, no, I need your street address because I need to be able to contact you. Is that correct?
You are specifically allowed to get the name and legal address of a requester. Yeah, code 2.2-3704, subsection A. That was added after 9/11. So yeah, it's all about identifying who's making the request, and you can definitely do that. I have had, and this to me, I'll just put this out there, especially for the lawyers. Generally, we've said a P.O. box is not a legal address. Legal address is usually an actual physical address. But I have had one person contact me and say, I use the P.O. box for everything as my legal address. And so it could be. That's an issue that's kind of unresolved. But typically, if we're talking about a citizen, we're talking about their residence. If we're talking about a business, it's their primary place of business or headquarters, main office, that kind of thing. Any questions about that? Okay, let's talk about responding to a request. And for this, I need everybody to go back to grade school and give me a hand up, please. And for those listening, please raise your hand because it'll help you in the long run. Okay, this is, first we got to get in the right mindset. What color is George Washington's white horse? How many working days do you have to respond to a FOIA request? And how many responses do you have to choose from on this multiple choice test? 5. Okay, hands down. That's the easy way to remember, unless you are the six-fingered man from The Princess Bride, in which case I have to kill you. Oh, wait. Okay. Never mind. 5 working days. What's a working day? Oh, wait, what color is George Washington's horse? What's a working day? I heard it. A day when you're working. Yeah, it's a day when the office is open for business and people are working. Yeah. Is Columbus Day a working day? I heard a mix of responses, yeah. Okay, I'm at a state agency. Columbus Day is a state holiday. Our agency is typically closed. It's not a working day for me. For those in local government, show of hands, who is open on Columbus Day? Open for business. Yeah, I've got hands up. Who is not? Now I've got hands up. I use that example because some offices are closed, some are open. Working day depends, is your office open? Are you working? All right, any questions about that? Okay. If you received a request today, oh, do you have a question? Oh, there was a question. Oh, up at the top. Sorry,
You're right there.
Couldn't see behind the camera. Oh.
Where was it? Oh.
They've asked if, when you ask a question, if you would give us your name and locality. And good catch.
Thank you. My name is Soledad and I work for Fire and Rescue. So my question is, when I get a FOIA request for a fire incident report, obviously we're open 24/7, as in, fire and rescue, the personnel, they're out there, serving the public. So for them, even on holidays, Christmas, whatever, they work.
Right.
However, I may be at home on a holiday because our headquarters office is closed.
Right.
If the request comes in, however, for either a day that, say the incident happened on a holiday, or it actually came in via fax, email, whatever, because they may be wherever they are and they are working, how does that apply to me? Being that the record was produced on a non-working day for us on an administrative point, right? But the actual people that produced the record and whatnot and the response was at work.
FOIA talks about the office hours of the custodian of records. So we're looking at the people who actually handle the records requests. So if your office hours, say, are Monday through Friday, normal business hours, that's the hours we're considering as your working days to respond to the request, versus anybody in emergency services, police, fire, et cetera. You're going to have people 24/7, but those people are not usually the ones handling the FOIA requests, so we're not counting their hours. On the other hand, if you're typically we see this with libraries and museums. A lot of them are open 7 days a week and actually have records people working 7 days a week, so they might have a 7-day working day. Others don't. Yeah. Any other questions about working days? There? Behind the camera again.
your count doesn't start till you come back because you've let the customer know that you're not there. Is that correct?
It can be. I think it depends what office you're at, how many people do FOIA requests in your office, that kind of thing. You know, if you're at a large locality where you have multiple FOIA officers and other people can check the email and handle it, then one person being out isn't going to really affect anything other than what, you know, if somebody directly contacts you and they don't contact anyone else, then yes, I'd want to have an out of office letting them know I'm out, I'll be back at such and such date. And for that, the request isn't really received until you get it. For other things, I mean, I'll give you the small town example. I've talked to a small town clerk. Her hours are 8 to noon, Tuesday, Thursday, Saturday. 5 working days is almost 2 weeks, just because she only works 3 days a week. Yeah, and that was another point there is half day counted as a day. The law, you know, for the law, I found an ancient case from the 1800s saying a day is a day. Fraction of a day is still a day. So we count it as a full day. You're welcome. Any other questions? There's one over here.
Can you raise your hand real quick? Oh, perfect. I won't chuck this at you.
So I work for the Fairfax County Tax Department, and we will occasionally get requests for information, but without any specific details. They're just asking how they would make a request, and we respond to them in a reasonable amount of time, but occasionally we don't get a follow-up response, whether because they forgot about the request or maybe they realized that they didn't have the information that they wanted. At that point, is it our responsibility to follow up with the requester, or is it the requester's responsibility to follow up to meet the 5-day amount?
So if I understand, they're contacting you about how to make a request, but they're not actually making a request?
Right, they're asking if they can get information about, in this case, like a business, but they're not giving us any names or addresses that we could reasonably search with.
So it's more a process rather than actually for, you know, they're not really asking for a specific record?
Correct.
Yeah, I'd say that's not a FOIA request, not yet. I mean, it's something I do encourage requesters to call ahead, talk to the FOIA officers or the PIOs, and a lot of the time, you'll see kind of a communication disconnect where we in government know what we have, we know how we keep it, we know how it's organized, but a citizen doesn't. And so they may expect you to have something in a way that makes sense to them, but it's just not the way you do it. And so when situations like that happen, I always encourage them, call them up and talk to them. Ask them what they have, how they do it. So it sounds like you're getting calls kind of like that of, hey, do you have this kind of information? How do I go about getting this? Where do I go? That kind of thing. That's not technically a FOIA request because they're not asking for a record with reasonable specificity. Okay. If you got a request today, what is day one to respond? Yeah, tomorrow? This is Friday, isn't it? Am I in the twilight zone? So Monday would be day one. What's day 5? Friday. Yeah, so the general rule, you have a week, basically, if the weekend is not a working day. If there's a holiday, you get a little more time. I want to go into the 5 responses a little bit. I'm going to jump ahead to the before. One of the responses is if you need more time, you can invoke an additional 7 working days to respond. To do that, you have to respond within the first 5 saying, we need 7 days more because, and you have to identify why. The law says you shall state why. Okay, so don't forget to do that. We've seen people forget, and if you don't say why, we don't think you get the extra time. Also, you can't go on day 6 or day 7 and say, hey, I need 7 more days. You got to do it within the first 5. Okay? If you do that, you now have a total of 12 working days. That usually includes 2 weekends, so you got about 2.5 weeks there, grand total. That's usually enough for most requests. If it is not, the next part of the law says you shall make reasonable efforts to agree on the production of records with the requester. Okay, so you got to talk to them. As I said, communication can solve almost all your problems in FOIA, but talk to them and make a deal. If you can't work out a deal, you can petition a circuit court for more time. I can tell you exactly how many of those petitions I've actually seen. It's 0. Okay? I've heard of them being filed, but I've never seen one. Almost everybody ends up working out a deal. Okay? So almost always you can do that. Okay, so the timing, just to reiterate, you got 5 working days. You can get an additional 7. If that's not enough, make a deal with the requester. If you can't make a deal, you can petition a court. Okay, so that's the timing. Let's talk about the other responses. What do you think the #1 response to a FOIA request is? Oh, no. What's the whole point of FOIA again? Transparency, yeah. The policy says every public record is open by default. Can I have that? Yes, here. Yeah, your #1 response is here. Here it is. Go ahead. Okay, so that's your first one. If that's what you're doing, that's all you have to do. Some people ask, well, don't I have to write a cover letter? And I go back to that example of, okay, I just asked for a permission slip at the school. Are they going to write a cover letter before they hand it to me? No. You don't have to write a cover letter. Just give them the records. You can write a cover letter. It's okay to. But if you do, what have you done? Yeah, consequence of choice. You created another public record. And we said a FOIA record retention period is 3 years. So you got to keep that cover letter for 3 years if you choose to make one. Again, not good or bad, not right or wrong. It's just a consequence, so be aware of it. Okay? #1 is yes. Then #2, we're getting on to #5 down there. We'll get to don't have it. I know it's everybody's favorite sometimes. I don't have it. Bother them, right? Yeah, some people think of it that way. I'll jump ahead to that one. If you do not have the record, tell the requester, okay? This is the record cannot be found or does not exist response. If you know that someone else does have it, then you have to provide contact information for that someone else. I'll give you a personal example. We used to get a lot of calls for Medicare, Medicaid records. I once got a call from someone who said, I'm at a hospital in Wisconsin. I've got a Virginia resident bleeding out in the ER and I need an out-of-state Medicare provider form, please. And I said, call DMAS, Department of Medical Assistance Services. They do Medicare, Medicaid for Virginia. I don't have that form, okay? Usually if you don't have it, it's, like I said, some people just don't know what we have and they ask you for something that just isn't yours. It would be a different department, a different agency, different locality. Someone goes to, okay, where I live in Chesterfield, I had this a while ago. There was an article in the paper about a VCU student getting arrested. They went to Chesterfield Police and said, I want to see the arrest report on that. And they said, we didn't do it, it was Richmond Police. So you got to go over to Richmond. Okay? Usually this is pretty simple, obvious stuff. The problems we're having is sometimes, because this didn't used to be in the law, someone would get a request and they'd look at it and go, well, that's not ours. We don't have that. And then they wouldn't respond at all. Well, FOIA also says that failure to respond is deemed to be a denial and a violation of the chapter. So if you simply don't respond, then that person calls me up a month later, 6 weeks later, and they say, hey, I made this FOIA request. What do I do? They won't respond to me. Well, deemed a denial, deemed a violation. Statutory remedy is to file a petition in court. And then the public body ends up in court and they say, well, that's not our record. We never had that. We're not the custodian. So it now says in the law, if you don't have it, you have to tell them, okay? Also, I had this yesterday. Someone said, well, they're supposed to have these text messages, but they deleted them. Doesn't FOIA require me to go to the ISP to go get them? Well, FOIA just says you have to produce existing records, all right? It says you may abstract or summarize from existing records. You may create records by agreement with the requester, but you don't have to. We had a question in here about that. If a requester seeks public information maintained in a database, but a report does not currently exist which includes exactly what the requester seeks, then should the public body be required to create a report to include the same? If yes, will the cost to create that report be considered allowable under FOIA? All right, with electronic records, there's a provision in FOIA in 2.23704 subsection G that talks about electronic databases must be produced in any format you use in the regular course of business at the request of the requester, their choice, and it says converting from one format to another or excising exempt fields from a database is not considered creating a new record. Okay? Otherwise, you only have to create a record by agreement if you choose to do so. So when we look at a database, I always ask, what is the database? What's it designed to do? What's your software designed for? I like the example of mapping software, GIS software, because usually the GIS data is already in the system in some sort of mathematical form in a group of tables. It's got software that will then punch up a map when you put in whatever the parameters are you want for that map. When I see somebody doing that, you may have never created that particular map before, but what you're really doing there is converting from the mathematical tables into a graphic visual map. And you've got software that's designed to do that. It's something you do in the regular course of business if you do GIS. So we don't look at that as creation of a new record. On the other hand, my favorite example, because I was a psych major in undergrad, there's a theory that as temperature goes up, people get angry and they get more violent. Violent crime goes up with temperature. This has actually been shown. It's a real theory. So let's say I'm doing some graduate work in psychology and I come to the local police and I say, I would really love a neighborhood map that's got all the neighborhood crime statistics for the last year with an overlay of temperature. Can you give me that? Anybody have that? Show of hands. Okay, I've been using that example for over 10 years. I have seen one hand go up. They said, yes, I actually did that, because it is an actual theory and they wanted to test it. So it can be done. But let me ask, okay, you're wearing law enforcement? You have crime statistics, right? By neighborhood? Is it in a map form? Not created like that. Any GIS people here? No? Okay. Well, if somebody asked you for that, you would say, well, we have these crime statistics and they're listed by neighborhood, but not necessarily on a map. I can give you this. And then I can go to the GIS people and say, okay, can I get the neighborhood maps? Here's the neighborhoods the police use. Can I get the maps? Okay, great. And then, oh, who has weather data? Let's go to somebody who's got weather data. And then I can create the thing myself. Now, if you have an enterprising programmer like that one person who said they actually do it, you could decide, hey, we'll make an agreement with you to do that. And then the next question here is about the charges. Yes, you can charge for that because that's part of agreeing on the terms and conditions of creating the record. So you could charge for it, and what you charge will depends what you agree on with the requester. Okay. Responding to records, we said, number one is yes. We jumped ahead. We've already done timing, and if you don't have it, there's 2 more responses in there. So number one is yes. What's the opposite of yes? No. I'm not going to give it to you. Okay? If you say anything other than yes, so if you're saying no, if you're saying we don't have it, if you're saying I need more time, you have to do it in writing. Okay? This is where I said if you're giving them the record, you don't have to create a cover letter or anything. Well, if you're saying no, if you're saying I need more time, if you're saying we don't have it, then you do have to create something in writing to respond to the requester. Okay? If you're saying no, you can do so either entirely or in part. These are your other 2 examples, or excuse me, responses. The example is if the record is entirely exempt, everything in it is subject to an exemption, then you can say no and withhold the entire record. If only part of the record is exempt, then you can only withhold that part that's exempt. Okay? Anytime you say no, you have to cite the law that allows you to withhold the record or requires you if it's a prohibition. I like to use an example of schools. Do we have anybody from schools here today? Okay, we have a couple. So let's say you were doing a math department report covering a 5-year period. It's got SOL scores aggregated, some overall performance of the department type stuff, and you had that as your main report. And then as Appendix A, you have individual reports on the success of individual math teachers by grade and identifying the teacher themselves. And then as Appendix B, you have individual student scores listed on their tests and everything. Okay. Would you turn over the whole thing? No. Would you turn over that first part that's all aggregate and statistical information? Yeah, that's going to be open. Then you're going to withhold the rest as either personnel or scholastic records. Okay, so that's here's part of it, here's the other part. Now, if you were going to withhold an entire record, you have to identify the volume of the record and the subject matter of the record. If you're withholding just a part of it, you only have to identify subject matter because they can usually see what's missing, so you don't have to identify volume. Okay? So again, if you say no, cite your exemption, identify your subject matter. If you say no in whole, identify volume. If it's in part, you don't have to identify volume. Any questions about saying no? All right, I don't see any hands up. Okay. Okay, we're good. So we've got electronic records. Oh, charges. We didn't talk about charges yet. Who wants to talk about money? All right. FOIA says you may make reasonable charges not to exceed your actual cost incurred in searching for, accessing, duplicating, and supplying the requested public records. Okay? I used to do an hour-long thing just on charges, so we could really get into the weeds if you want to, but let's try to start with high-level stuff, okay? First part, FOIA says you may make reasonable charges. That's permissive, right? Okay, so you don't have to charge, but you may charge. Do you think the school's going to charge me when I ask for a copy of a permission slip? No, they're going to say here. On the other hand, if you get a requester who comes in and I've heard this rumor about Fairfax that you all had a request that went over $200,000 once. Is that true? Anybody know? No? Okay. Someone said, maybe it was City of, I don't know. Somebody said that there was a request several years ago that went over $200,000, I was told.
We get lots of requests that could be $200,000.
It could be. But none that actually were? Okay. Well, first thing to keep in mind here, there is no upper limit, there is no lower limit. It says may, and it says actual. So actual cost is always your top, but actual cost could exceed, you know, 10,000, 20,000, 100,000, 200. I mean, there's no specific limit. Some people say, you know, what's the total you can charge? There isn't one. Some people say, what is the statewide average? Doesn't matter. It's the cost to you. It's the actual cost that we're talking about. In other versions of FOIA, federal law in some other states, you'll see waiver provisions. A lot of times they'll tell you you should waive the charges if. Some examples would be if the person is indigent, if it's a student doing something for an educational purpose, if it is a media person who is doing something in the public interest, various other reasons. We do not have that in Virginia. Okay, we just have the permissive may. Now, you are welcome to take those factors into account and not charge people if you don't want to charge people, but you're always allowed to charge. Okay, so any questions about waiver there?
Could you charge one person for one thing and a different person for, or not charge a different person for the same thing?
You could, but I'd be careful about it. Classic example where you would, and this gets to the actual cost, is let's say someone comes in and says, hey, I want to get such and such records, and you look into it for a little bit and say, you know, that's going to be a lot of search time, and I don't think it's going to produce a lot of material. We can do it for you, but let's say, hypothetically, it's $1,000 search cost, $50 in duplication supplying. And they say, okay, and they come in, they get it, you know, the following week, they cut you a check, and the person behind them online says, I'd like what they just got. Can you charge the search twice? Nope. So they're going to get it for $50, the cost of duplication and supplying. So there would be one where, because it's an actual cost limit, you wouldn't charge twice for the same search. On the other hand, someone comes in and does that. Let's say you put all those records back where you found them, and 5 years later, somebody else comes in and says, hey, I'm interested in blah, 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 blah. And you go, you know, we did that years ago, but we don't have it all collated together anymore. We're going to have to repeat the search. Well, now you'll be doing it again at whatever that cost is. Talking about exemptions and also charging. Charging says may, exemptions are discretionary. I would caution everyone, use your discretion carefully, okay? You don't want to have a civil rights violation. So ask yourself, why am I charging this one person and not this other person if you're ever going to do it? Because FOIA doesn't specifically say you can't. It doesn't set specific limits on your discretion. I'm going to use a charging example of, this is a real one. Town clerk calls me up and said, we have a woman who's been making a lot of requests. We didn't used to charge. We normally don't charge anybody, but she was making so many, we actually had to, you know, get a new ream of paper and change the toner in the cartridge, toner cartridge in the copier, and it was just getting to be a problem. We started charging 5 cents a page. What do y'all think? 5 cents a page? Keeping in mind, charges have to be reasonable and within actual cost limits. Yeah, that's probably okay. She went on. Well, it was still costing us more than we were, taking in, so we started charging 10 cents a page. I'm getting a little iffy. Well, they started charging 25 cents a page. She's still making requests, and now the town council wants to charge 50 cents a page, but I don't really think that's right. And I said, I don't think that's right either. Let me ask you, why were they charging 25 cents a page and want to raise it to 50? Yeah, they want to deter the requester. They're trying to stop her from making requests. Okay, so you can't do that. I mean, the whole point of FOIA is to provide records, right? You can't use charges as a weapon. So, again, your discretion on charging or not, don't use it as a weapon, but you can do it to recoup your costs. That's what you're allowed to do. All right. Another story, and this goes back to who can make a request, but it also kind of illustrates the idea of discretion versus discrimination. I had a call from an assistant to an elected official at the local level. I won't say who or where. And she told me, well, we've got this request, and I'm just not sure. I'm not sure about it. And I said, what are you not sure of? I'm not sure that, we actually have to respond because, well, I'm not sure if the person's a citizen. I said, well, did you get their name and address? Well, yeah, we got that. Do they live in your county? Yeah, they're in our constituency. So what's the problem? And she whispered to me, the last name is Torres. I said, what? So what's the problem? Yeah, so don't do that. Everyone gets that one, right? Okay, we have a question.
Related to charges, I wanted to confirm, you cannot require payment in advance unless it hits a certain level.
Correct.
Right?
Yeah, with charges, upper limits actual costs, like I said, and we can talk about the things you're allowed to charge for, but there is a provision that says if the requester wants one, they can get an estimate in advance. And it also has another provision that says if your estimate exceeds $200, then you can get the money in advance as an advance determination, advance deposit. So threshold is always $200. If they ask for something and you estimate it's going to be $175, you are not allowed to get the money up front, okay? You can talk to them about it. As we said before, you can always negotiate with the requester. And a lot of people, in my experience, you say $175, a lot of people say, whoa, I don't want to pay that much. And especially, we were talking email before. How much does it cost to search for email? It depends, yeah. If it's an email from last week that's still on your computer right there, probably pretty much nothing, right? Nominal charge, and you just forward it to them and you're done. If it's a series of emails about a controversial issue from 10 years ago between all of your board members and a number of high-level staff people, do you have your emails from 10 years ago on your desktop? Ready to hand? Do you have to go to the IT people, pull them from a backup or an archive, check folders, see if anybody had a main folder about that topic, et cetera, et cetera? How many people can search, I want to see all your emails for a 2-week period from 6 months ago? Or this is one of my favorites. This is about charging and emails. And this is, again, real. We had a situation with Sweetbriar College was going to close a few years back, and a woman asked the Attorney General for everything they had about the closure, including all emails, communications, et cetera. The way her request was phrased would have required every employee at the Office of the Attorney General to search their records. They gave her an estimate of $19,500. She protested, she complained to the newspaper, and the Richmond Times-Dispatch wrote up an article about it, so you can go look at that if you want to. My understanding is, from talking to the AG's office, that would have been 400 attorneys and 200 support staff all searching their records. I'm looking at that and going, okay, so if the attorneys just charged, maybe $100 an hour, and if everybody could charge, say, half an hour, search their entire computer, all their stuff in half an hour, that would still be 200 attorney hours. At $100 an hour, that would be $20,000. They actually gave her a discount, didn't they? Yeah, but at the same time, put your citizen hat on and think about it. If you got this, you said, I just want emails about, closing the school, and they tell me I'm gonna have to pay for basically a new car. That's crazy. Is that reasonable? Doesn't sound like it. Well, as I said before, communication is key. They talked to her. They worked it out. They got it narrowed down to the people who were actually involved in the project. And I think it was still a couple $100 because there were a lot of records there. But they narrowed it far down from that 19,000 plus estimate that they started with. Okay, so always talk to somebody. On charges also, accessing records. In a paper world, that usually meant physically going somewhere to get the records, whether it's offsite storage, down in a basement, whatever, you're actually physically accessing something. Digital world, I've been told, examples here are going into your backup tapes, going into archives, getting the IT people involved to pull something that otherwise is not easily accessible. So there can be charges there. Supplying records, paper world versus electronic world. Paper world, it's going to be stamps, envelopes, maybe a banker's box or two, shipping charges, whatever, depending on the volume. Electronic world, it's usually attaching something to an email, hitting send. Okay, so usually the electronic one is pretty nominal. It can be more. Sometimes you might be putting stuff on CDs or flash drives and mailing it to somebody. There can be more charges there. But usually the electronic charges are a lot lower for that and duplication, the copy charges. Paper world, if you go onto our website and look under the reference materials, we have a charges guide. There's a formula in there so you can actually figure out what it costs to produce one copy. We recommend, not that you do it every time you get a FOIA request, but whenever copy charges, supply charges, all that, whenever things change, have your finance people just kind of run the formula and you can figure out what that is. That way, if you ever end up before a court and they say they charged me too much, well, here's what we did, Your Honor. Here's how we figured it out. Again, copy charges for electronic records, usually nominal. You're usually not, there's very little involved. Search charges, that's the big one. That's where, how many emails did you get today? Yesterday, last week, for the last month? How many went into spam? How many got filtered before you ever saw them? I mean, there's all sorts of questions about email and the sheer volume of it. What we found is that search costs have gone way, way up ever since people started using computers and email. People thought, hey, it'll be real easy. We'll put in a keyword and run a search. That, unfortunately, has not been the way it worked out. Sheer volume is huge. So search costs is the big one. The Virginia Supreme Court had a case a few years ago, I think it was 2014, American Tradition Institute versus Rector and Board of the University of Virginia. This case made headlines because it concerned Professor Michael Mann and his climate change research, but one of the more telling parts of it was actually about charges. The court upheld the lower court's decision, which said you are allowed to charge for exclusion review, meaning, and I use a funnel analogy here. Remember we talked about the definition of public records? Well, you start with all your records, you narrow it to the ones that are actually public records, you then go through anything exempt or prohibited from release. At the bottom, that's what you're actually putting out. And the court basically said you can charge for that whole process of exclusion review. So you can charge the staff time there. I would note we've got an opinion, staff time means hourly rate, does not mean benefits. You don't need to have vacation time to answer a FOIA request, so we don't count the benefits part. Any questions on charges on that part? Okay. Let's talk a little bit about...
I do have one quick
oh,
question.
You have one, okay.
There was one submitted in advance. And
that's right.
Did
Number 3?
Yes.
On here, okay. Yeah, can a public body charge for actual labor costs related to an email search or any other type of record search which results in no responsive records? Technically you can. FOIA says you're allowed to charge up to actual cost incurred. It doesn't say what the result of your search would be. So technically you can, but I would strongly urge you, if you think you're going to be doing a search that's probably not going to turn anything up, talk to the requester first. Okay, I'll give you an example. I forget which jurisdiction. We had actually a formal opinion about this years ago where a woman asked for records from a police agency about her sister's rape in the 1970s. And they said, well, if we have any records, and I don't know if we do, but if we do, they'd be in offsite storage because of the time period. We can go look for them, and if we look for them, we're going to charge you for them. And just so you know, even if we find them, we're not going to give them to you because they're part of a criminal investigative file. Okay? And she had a lot of issues with that. Technically, it was a compliant with FOIA response, and I think she decided not to go forward with that one at that time anyway, because they said, even if we find something, and I don't know if we will, we're not going to give you anything, but we are going to charge you for the search time. So yeah, I mean, if you have a situation like that, tell the requester up front. Any other questions about charges?
Yeah, when you're calculating staff time, let's say you have something that is
confidential or you can exclude it, and you have your attorney to review it. Are
Right.
you allowed to then go ahead and charge for the attorney review time?
It depends. Sometimes yes, sometimes no.
So in-staff attorney versus
Well,
contract
no.
attorney?
What we've said is if it's secondary legal review, where the attorney's already had somebody else actually go through and do all the redactions and everything, and they're just double checking it, we said we don't think you can charge for that because the redaction's already been done. On the other hand, a lot of time the attorney is the one who's actually doing the initial work, and in that case, yes, that's the actual cost. You can charge for that. That on that point, I would note in our charges guide, you'll see we recommend generally have the lowest paid person who can do the work. That saves time and money. It's more efficient for your office. There are times when a higher level person is the one to do it. My personal favorite example is, let's say you have a new jail being built and the sheriff's involved in the contract negotiations. Something goes wrong, it becomes controversial, and the newspaper reporters come in and say, hey, Sheriff, I want all of your emails about these contract negotiations and building the new jail. Well, most of that stuff's probably going to be open, not exempt. But who's going to do it? Who's going to actually search for that? Do we have any sheriffs here today? Okay, I don't see any. I do training for sheriffs. Oh, we do have one, okay. So would you do it yourself, or do you have somebody else do it for you? Okay, so you have a department that would do it for you. A lot of sheriffs I talk to, especially in smaller localities, they don't have anyone else who's going to do it, and they don't want to give their passwords to anybody else, so they do it themselves. And I think that's justified, and they're going to charge their rate as the sheriff when they do that. Same with police chiefs, other people who are dealing, constitutional officers, it's pretty regular. If you ask for emails from the county attorney, I imagine the county attorney might be the one to actually answer that. Other things, if you're looking through stuff for attorney-client privilege, that's one where the attorney is often the one doing the actual work. So there are times when it is completely legitimate that higher paid people are the ones doing it. But as a general rule, especially if it's just, pull this copy, make a copy, mail it to somebody, it's better to have administrative staff or someone who can do it as a ministerial task. Any questions? Okay, let's talk just a little bit. Oh, we do have one.
My understanding with subpoenas for documents, there's no charges?
Subpoenas fall outside of FOIA, so you can't use the FOIA charges. I have very rarely heard of a court allowing somebody to charge when it's a huge volume or something, but that would be specific to the court, I think. You'd have to ask them. I would defer. Any other attorneys know of situations where you were allowed to charge in response to a subpoena? Yeah, I've heard of like one ever. And I think they said that was over 8,000 copies of records or something. So maybe, but not normally. There is a provision in FOIA, just so everybody knows, 2.2-3703.1 specifically says that the FOIA exemptions and FOIA rules do not apply to court orders and subpoenas. Our understanding is there actually was at least one, maybe two cases at general district court level where someone got a subpoena quashed based on a FOIA exemption, and that was never really the intent. They're two separate procedures. Okay, any other questions on that? All right. We've already talked a little bit about some of the exemptions. Just so you know, general exemptions that pretty much everybody can use structurally in FOIA are found in 2.2-3705.1. Start with the very first exemption is personnel information. First paragraph basically says personnel information about identifiable individuals may be withheld, except you have to give it to the individual who is the subject of the record. The subject of the record may also waive the protection of the exemption. Now, some people have interpreted that to mean the subject has to sign off before you can give out records. That's not true. If the subject waives the protection, that means the exemption does not apply and you can't use it. So anytime somebody asks for it and it's been waived, you would have to release it, is what that means. You can still release stuff even if the subject doesn't want you to under FOIA. Now, there may be other personnel policies, other reasons why you wouldn't, but under FOIA you could. Examples of that, I like to use police as one example, and I'm going back. Usually it's good and there's bad, okay? You get a new police chief. Do they release, this guy came from this department, their crime stats went down, he's got all these certifications, he went to school here, there, the other, all the gold stars on the resume. They're gonna release almost all that stuff when you get a new chief, right? All that stuff is personnel records. They don't have to release it. It's personal information. You can withhold it. But they choose to, voluntarily. They want to. The flip side of that is when things are really bad, and this is not a Virginia example, this is from, I used to live in Indiana and this happened out there, but there was a crazy college party and people were getting arrested, and one of the officers got a college kid, hog-tied him up, hands and feet, put him face down in the back of the cruiser, and then beat him up. Kid ended up in the hospital, and in the course of doing an investigation on it, they found the officer had done the same thing in a different state a couple years before. Okay, and the agency said, hey, look, this is what we know, this is what we found, and they released almost everything, and it was kind of, they're protecting themselves by saying, we didn't know at the time. If we had known, we wouldn't have hired this guy, but here's everything. We want to come out and be forward about it. Another police example, police-involved shootings. Criminal investigative files say you don't have to release hardly anything about those, because usually anything about those is either a personnel record, part of a criminal investigative file, or there's also an exemption for allegations of wrongdoing of law enforcement agency employees. So you can usually withhold just about all that stuff under FOIA. But I'll tell you, if you go down and talk to the papers down South Virginia who deal with Danville, Danville releases that stuff usually pretty quickly, and the papers praise them for it. They say, they don't have to release it, they choose to, and we're very happy about that. What do the Northern Virginia papers say? Yeah. Usually it's kind of the opposite. Not always. Depends on the situation, but obviously there have been situations where records have not been released in a timely fashion. I know at least one went to court, and then the court ordered records to be released. I would point out, though, that was a court order. That was not FOIA. FOIA did not require those records to be released. Under FOIA, it's discretionary. So you do have that option, okay? Some other general exemptions. Attorney-client privilege and work product. There are equivalents in FOIA to protect those, as well as the common law privileges. People ask a lot about, we had the question earlier about personal contact information. As I said, there's no general exemption for it, but usually in the context of whatever type of record is, there often is an exemption. There's a general exemption for account and routing numbers in financial documents, credit cards, account statements, that kind of stuff. Now, keep in mind, an accounting record generally is open except the actual account number or routing number, okay? Other ones, working papers and correspondence. This exemption gets a lot of press. It only applies to certain individuals that can use it. At the local level, it's going to be whoever's the chief executive for the political subdivision. So keep in mind, board and council members can't usually use it. County executive, administrator, town manager, they're the ones who usually get to use it. Okay. Question?
Yes. So recently we've been, let me start again, on matters that are closed session topics. Our town manager has been sending emails related to these topics, land acquisition, for example, and puts on the email closed session topic not open to FOIA. Is that?
Notices like that, and I imagine every attorney in the room has a similar disclaimer saying this may be attorney-client privileged, et cetera, et cetera. If you get this email in error, please delete it or notify the sender, that kind of thing. Stamp this as confidential, all that. They put somebody on notice that it might be exempt, it might be privileged, it might be confidential. They don't always mean that it is. You have to actually have a statutory exemption or other provisional law that says you can withhold this or it's prohibited from release, okay? The other one, big one, contract negotiation records. I'd point out there is an exemption for contract negotiation records where release would jeopardize the bargaining position or negotiating strategy of the public body. That applies up until the award of the contract. There are also procurement exemptions if you're doing something under a specific procurement act. So if anybody's dealing with procurement, please know which law applies to that transaction because there are different exemptions for them, for the different types of transactions. Okay. That pretty much concludes the CLE portion. I would like to just finish by noting what happens if things go wrong, okay? The basic remedy in FOIA is for the person to file a petition for mandamus or injunction. They get to choose to file in either general district court or circuit court. The petition is supposed to be supported by an affidavit showing good cause. Some of you may be familiar with the Supreme Court, just had a case about such affidavits from Rappahannock, just went up to the Supreme Court and they talked about the necessity to swear to the facts and all that, so be aware of that. The basic remedy there, everybody knows what a mandamus is, right? I'm seeing heads nodding, I'm seeing, yeah, okay. Think the word mandatory. It's something you have to do. So it'll be the judge ordering you to do something you're required to do by law. Usually in the FOIA context, we'll see this in records situations where someone says, they should have given me this record, they either denied it or they just didn't respond, or for whatever reason they didn't give it to me. Your Honor, order them to give me the record. So that's your typical mandamus. Injunction, pretty much everybody knows, that's when they tell you not to do something. So effectively, the court's going to tell you to do your job right if you do it wrong. Okay, how many people are scared? I didn't see any hands go up. Nobody's scared of that? All right, how about this? If they win, if they substantially prevail on the merits of the case, they shall be awarded attorney's fees, court costs, and any expert witness fees. Is anybody scared yet? Okay, I saw one hand go up. So anybody from Culpeper? I drove through Culpeper on the way up. Anybody remember Culpeper built a high school about 10 years ago? Well, they had a FOIA case that went from general district court to circuit court all the way up to the Supreme Court, and in the end, the Board of Supervisors lost that case. And if I recall correctly, the headlines afterwards said something about, your Board of Supervisors violates your right to know and pays the other side's attorneys $93,000 of your taxpayer money in doing so. Anybody want that headline written about them? Okay, so yeah, the basic remedy is the court tells you either to do or not to do something that you're already supposed to do, but then there can also be the monetary side of it. That would be paid by the public body. There's another provision in the remedies section, the following section actually, which says if you are found to have committed a knowing and willful violation, you can be made to pay a civil penalty to the state literary fund of $500 to $2,000 for the first violation, $2,000 to $5,000 for second and subsequent violations. Okay, this is knowing and willful. It's a high standard of proof. I've seen a couple cases, but even the one I used to use as my favorite example actually got overturned on appeal. There was a situation where citizens group asked for a copy of a contract with a parking garage and a town. The town told them, there's no written contract, it's just a verbal agreement. That was in 2008. They said that when 2011, 2012 rolled around, they asked again because someone leaked to them, no, there's a written contract. This time they got it, and they said it was dated to 2006. It went all the way back to there. The lower court found the town manager had lied, is what he felt, and fined him $1,000. My understanding is the manager originally said, well, no, there wasn't a written contract at that time. Well, when I found an article talking about the appeal, when they went to circuit court, the contract was from 2012. They had renewed it and done a written version later, apparently, and so he got out of it. They took away the fine for knowing and willful. We've only seen one case go all the way to the Supreme Court and get upheld for knowing and willful, so that's a pretty rare thing. The other thing, and the other reason I want to mention it, is there is a bill that has passed the General Assembly. The governor has not yet acted on it. If this bill goes into law, it creates a penalty for the improper destruction of records where the intent is to avoid FOIA of $100 per record. It also creates a penalty for improper certification of a closed meeting. And I forget, I think that's up to $1,000. One is up to $100, the other's up to $1,000. And that's if the attorney is present when they have the closed meeting or certify it. I understand there's some controversy about those going on right now, so we'll see what happens and if they're enacted, but please be aware of that. Any final questions before what we're going to do, because we are scheduled to go till noon, I believe. So we're going to break for those who need to leave, and then we'll take some more specific questions, but I see one hand up in the back.
Thank you. I had a FOIA, they called it in, they sent me a request through the email, but then 2 days later called and said they want to come in to see the documents, but it was after our 5 days. Do I still have to respond to him in a letter?
Well, if they say we want to come in and it's after the 5 days, I would just work out the agreement with them to do it. And I would probably, since you have their email, I would write in, as you discussed with me by phone, you're going to come in on such and such a day, and just wanted to memorialize it. Here you go. And that way, if there's a problem later, you have something in writing that you can refer to that says, no, we reached a deal on that. So the normal 5-day requirement didn't apply because we agreed to do it otherwise.
Thank you.
Any other questions before we break? All right, here's one.
Down here. Okay.
Okay, I'm not nervous anymore. I caught the box. Okay, my question is, how do you manage elected officials and employees when they conduct business either by texting on their personal phones or emailing on their personal phones? Because you say you have to have the record,
right?
And technically the government doesn't have the record.
Yeah, I would look first to check the Public Records Act retention schedules on the library's website to determine whether they need to keep any particular record. Depending what it is, a lot of, I use this example because I've talked to the library folks about it, but I'm going to be 5 minutes late, traffic's real bad, but I'll be there soon. You get that as a text, and then they show up. You probably don't have to keep that text. On the other hand, an email from your chief executive saying we are about to change our policy on procurement deals. We're no longer going to do them this way. We're going to go and use this thing. It's going to be for the whole locality, blah, blah, blah. Well, that's probably something you have to keep for some period of time because that's more important. So that's the first question. Do you have to keep it? If you do, I encourage everybody, number one, as I said, best practice, use your government account. Don't use your personal if you can avoid it. So that's the first step. Second, use your government device if you've got one. If you don't, like I have a cell phone, we have Gmail. So it doesn't matter what device I use. It's all in my Gmail account, and it's my government Gmail account. So it doesn't matter. Texting, personally, I don't do it. That's my own decision. I just don't like texting. You can keep texts. I've talked to various people. You're IT, right? All right, you're going to want to talk to IT people about how to keep your text. My understanding is, depending on your provider, whether you're using an iPhone, an Android, there can be different things involved. As I said, I don't really do it, so I'm not good to go on the technical side, but it is possible to keep text. I know there's been at least one case that was filed where they actually settled out of court, so there's no decision to refer back to, but they asked for texts. The allegation was you didn't keep them and therefore defeated FOIA, because if you had kept them, I could have gotten them under FOIA. And the agreement they reached was, okay, well, we can't retrieve the ones that were already done because they're gone, but we will keep them going forward. So I would check, like I said, first thing is check those retention schedules to see if it's something you need to keep. And then you got to figure out how to do it as a technical question. With email, if you do choose to use a personal account, especially with elected officials who use personal accounts, have them CC a staff person, chief clerk, administrator for whatever their body is, and say, anytime you do public business, please CC this staff person. This came out of, I think it was Fredericksburg back in around 2003, had a suit because they were giving their members email accounts and laptops, and of course they had their home accounts, their work accounts, their personal computers, all this stuff. There was some controversial issue where they were using all these things, and it ended up going to court. And we talked about discovery earlier. The court was making them turn over their hard drives of their home computers, as well as their government laptops, well, everything. And they were looking at everything. So they implemented a policy to say, hey, look, anytime you do public business, CC staff. If you're going to use a personal account, they encourage them not to do that in the first place, but if you're going to, make sure to send a copy to staff, make that, treat it as a religious ritual, always do it. And that way, if you ever end up in court on it or anything else, I always CC staff. They've already got it. And then they've already got it. So that's the practical.
I actually have a question. I have a question too. We have holder of records agreements with other agencies, and so I have access to those digital records. I can view them electronically, but I cannot print them. If I get a FOIA request for those records, am I responsible for releasing those?
I would probably direct them to the other agency that can actually, has full custody of them.
Okay.
Yeah, I mean, you can get into some nuanced questions about who is the proper custodian. It is possible for there to be multiple custodians, but that's, talk to me later.
Okay.
that can go on for a while, that discussion.
Okay, thank you.
Let's take one more question, then let's break.
What's your opinion on services like Archive Social for?
Don't.
Okay.
Or well, depends what it is. I mean, Archive Social, if I remember right, that's the one that'll keep all your social media posts. So that actually would be good probably for retention. But I'm thinking of things, I can't remember the name of it, but ones that just disappear automatically. Snapchat, yeah, Snapchat. I think Facebook now has Facebook stories, and they kind of pop up and go away. I wouldn't do those for anything with public business because you might have a retention period, and you can't comply with the retention if it disappears. Okay. Thank you all, and I will be here for a little bit. Thanks.
Let's give our speaker one more round of applause here for coming.